even though the law is clear. If you tell everybody, oh, the law is unclear, you have to wait till the woman's on her deathbed, as certain people in elected office are saying these days.
Yeah.
That does create a cloud of confusion that we should not let them perpetuate, but that's what's happening here.
Welcome to Caring for Both, a curbside consult series by the American Association of Pro-Life Obstetricians and Gynecologists, or APLOG. On this podcast, we bring on experts to provide insights to support you as a medical professional in your life-affirming practice and career. I'm your host for today, Dr. Christina Francis, board-certified OBGYN and also CEO of APLOG. Today, I'm excited to be back with Erik Baptist, who serves as Senior Counsel and Director of the Center for Life at the law firm Alliance Defending Freedom. In this leadership role, Erik collaborates with pro-life allies, works with members of Congress and their staff, and engages with international, national, and local media on pro-life matters. He is a member of the DC and Virginia bars and has litigated before the U.S. Supreme Court and many federal appellate and district courts. Washingtonian Magazine named him as one of the most influential people shaping policy in Washington in 2024. And it is a privilege to know him. Of course, you all know him. Erik has been on the show several times to talk about our federal lawsuit against the FDA over its unlawful actions regarding the abortion drug mifepristone. But today, he's here to discuss a slightly different topic. In October, the American College of Obstetricians and Gynecologists, or ACOG, published a statement titled, "Abortion Bans Are to Blame, Not Doctors." As the title suggests, the statement blames state pro-life laws for recent cases of women who face delays in emergency care when dealing with pregnancy complications, such as miscarriage, ectopic pregnancy, premature rupture of membranes, and more. I'm excited to bring our unique perspectives to this issue as both medical and legal experts. So, Erik, thank you so much for being here with us today.
Well, I'm always honored to speak with you and all your members.
Thanks so much. Well, before we jump into this really egregious, I think, ACOG statement, I want to first point out that something that our audience hasn't been updated on since you were last on the podcast. Congratulations on your new position as the director of ADF Center for Life. Can you tell us a little bit more about ADF Center for Life and what you're doing now as the director there?
Happy to. So the Center for Life is the generation of all our pro-life litigation and advocacy work in the courts. And so I'm honored and blessed to have moved over roles. I was on our regulatory team as when we brought the FDA case, but now, kind of going 100% into the life issue, I'm now directing our litigation. We are out in all 50 states trying to work on behalf of life, defending pro-life pregnancy centers and those on the front lines who are trying to do good, in addition to defending states' pro-life laws as well. So I'm very honored to be here. ADF, as you know, has a long track record of going to the Supreme Court and defending the pro-life movement all the way up the chain. So it's an honor to be here and to work what I'm doing now and get to speak into the culture and the conversation that we're having nationally in this post-ops world. It's an awesome opportunity and one that I don't take lightly.
Absolutely. Well, we're so excited that you have moved into that role and know that we will continue to work with you as an organization. And also, I just want our members who are listening or watching this podcast to know that that Alliance Defending Freedom and certainly their Center for Life also defends our conscience rights as physicians. And so we're so thankful for that. Because you're dealing with helping states defend their pro-life laws, I think you were the perfect person to have on to talk about this ACOG letter that came out, again, entitled "Abortion Bans Are to Blame, Not Doctors." This came out a couple of weeks or so after we learned of the tragic deaths of two Georgia women, Amber Nicole Thurman and Candy Miller, really from complications related to the abortion drug mifepristone, which we know, we've talked about it a lot, is a risky drug. And Amber Thurman in particular died of a known complication of that drug, which is sepsis and retained tissue. But of course, out of their deaths, there were those that were trying to blame their deaths on Georgia's pro-life law, stating that it was because of that doctors delayed care in taking care of Amber Thurman, and because of that Candy Miller did not go to the hospital to seek care when she was experiencing complications, when in fact, nothing could be further from the truth. Georgia's law in no way applied to Amber Thurman's case. Her babies were already dead when she presented to the hospital, and so Georgia's law did not prevent a DNC in that case, and she was facing a life-threatening complication, which also would have been, would have qualified her under the exception of Georgia's law. And similarly, Candy Miller had heard lies about Georgia's law, it appears, from what her family said, and was afraid that if she sought care at the hospital, that she would be prosecuted in some way because she had obtained abortion drugs, which of course Georgia's law does not prosecute women. And out of that, we at Applog stood up immediately and clarified the medical facts of what we could know, anyways, from publicly available information on these cases. And ACOG, I would say, was kind of conspicuously silent immediately afterwards until October 3rd when they issued this statement. And they joined with abortion advocates, as they often do, unfortunately, as a medical organization, in stating that no laws should be in place regulating abortion. What is your response to ACOG's claim that these pro-life laws, what they call abortion bans, are to blame for deaths like Amber Thurman's and Candy Miller's, as opposed to something else?
Well, my initial reaction was I was both shocked and not shocked by ACOG's letter. One, I was shocked that they would weigh in on this because what actually caused these women's tragic deaths was because of what ACOG has actually advocated for over the time when the abortion drug has been available. They have tried to erode those safeguards that the FDA initially thought were important. And so, for example, when Ms. Thurman went to North Carolina to obtain the drugs, the provider who gave her those drugs didn't have any follow-up care with her. There used to be a requirement to have 2 in-person follow-up visits to ensure no life-threatening complications presented themselves in a woman who took abortion drugs. Here, they pushed the drugs onto the woman, where those drugs that ultimately killed her, and then pushed her out the door, figuratively speaking, never to see her again. No follow-up care necessary under the FDA's regime. This is exactly what ACOG envisioned and wanted. And now that what the fruits of what they have pushed for have come home, and what does that mean to women? Like, so this is Miss Thurman. It's like she's in a dangerous position where there's no follow-up care and no one can screen her for these life-threatening conditions. And so she's got to determine for herself when to present to the hospital, when is the appropriate time. Are these the normal severe complications or adverse reactions to the drugs or not? But at the same time, when I say I was surprised and not surprised, I was not surprised because I think, as many of your audience members would know, that ACOG has become more of an extreme abortion activist organization. It is not mainstream by any means of the definition, that they don't believe any pro-woman, pro-life measures should be in place in state law to protect a woman or protect the unborn life at any stage of the pregnancy, shows how extreme they are. But when it comes to the specific issues in Georgia or across the country and other states that have pro-life laws, they have frankly misrepresented what each of those states' laws do protect and what they don't protect. But I think we need to be very clear here, because ultimately I'm going to pull up the language, because some people are like, people argue that the Georgia laws prevented the women from getting help that they needed. The doctors were confused by the law. Like, none of that is true. I mean, it doesn't take a lawyer to figure out what is allowed in these situations. But the state of Georgia has so many exceptions that Ms. Thurman would have qualified under, that there was no unclear term that would have prevented her from receiving life-threatening, life-saving medical intervention. Why she didn't receive that care, I don't know the details. We may never know those details. But I can tell you, it was not the pro-life laws that ultimately led to her death. It was, frankly, the abortion drug was the direct reason why, and also ACOG's advocacy to remove those safeguards that would have prevented her death or could have prevented her death over time. So in Georgia in particular, they have an exception in the doctor's reasonable medical judgment that if a medical emergency exists, she can have an abortion. That is very clear in the statute. And at the same time, it has to, if it's not just the death of the pregnant woman, it's or a substantial and irreversible physical impairment of a major bodily function of the pregnant woman. So again, there are multiple ways a doctor could intervene at that point, whether the doctor thought Ms. Thurman was going to die or not, or whether it was going to impair a future significant bodily function, would have been covered. And at the same time, as you noted, her twin babies were already dead. to the degree that there was no viable pregnancy at that point, that meant she could have had an abortion or a surgical intervention. It wouldn't even have been abortion at that point to remove the fetal remains and prevent sepsis from incurring. So there are many reasons why that ACOG leaning into this issue is surprising, yet not surprising.
Yeah, absolutely. Well, and obviously ACOG and APLOG, and you're with APLOG in our position on induced abortion, and obviously ACOG is in a different position. But just because they don't agree with these laws doesn't mean that they couldn't give accurate guidance as to what these laws allow for and don't allow for. There are ways of getting laws changed through the legislative process. The people of Georgia, if they're not happy with this law through their elected officials, could try to change the law in their state. Same thing with ACOG. If they want to advocate for, a different law to be put into place in Georgia, they certainly could do that and go through the appropriate processes. But while this law is in place, and we're seeing the direct effects of spreading lies about these laws, and that it is potentially leading to women either delaying seeking care because they're afraid from things that they've heard, or maybe doctors being confused because the medical bodies that they rely upon, like ACOG, are not giving clear guidance or accurate guidance about these laws. And ACOG's role in the field of OBGYN has been to provide accurate clinical guidance in many situations, not just related to the abortion issue, but they are supposed to be providing accurate evidence-based guidance for OBGYNs, as well as they help interpret laws that impact many areas of OBGYN for physicians. And yet for these laws in particular, they really are giving inaccurate information about what exactly the law prevents. There are those, ACOG included, who say that pro-life laws don't offer physicians sufficient guidance on. They say, okay, well, yes, maybe there's a life of the mother exception, or you can intervene to prevent permanent physical impairment, but that doesn't provide sufficient guidance on when physicians can and can't intervene. Partly, because I can speak as a physician. I know that the clinical scenarios that women present with when they're facing pregnancy complications can be nuanced and unique, and we could never potentially put out an exhaustive list for all possible cases. And so people say, because we can't do an exhaustive list, then none of these laws could possibly be specific enough for doctors to know when to intervene. I'm interested, I've got some thoughts from a medical standpoint, but I'm interested to hear your thoughts from a legal standpoint. Do you think these laws pigeonhole physicians, or do they actually provide latitude for physicians to make the decisions they need to make?
These laws provide the necessary flexibility for the physician on the ground to determine whether it's reasonably medically necessary to intervene in these situations. And you're right, you hit the nail on the head. Like, ACOG is always going to be saying, oh, it's not precise enough. It's just, we don't know whether it would fall in the reasonable medical judgment. The flexibility is given in the statute. That term is actually defined in many of the state laws as well. What is a reasonable medical judgment? And so that gives a lot of deference to the on the ground physician who's actually treating the woman, because there are so many different circumstances, situations. You can't actually write a statute. It's impracticable to ask this legislator to pass a law that envisions every possible scenario. And if you happen to miss that one scenario one presents, and oops, you can't do it. That's why you go with the flexibility and deference to the doctor who actually knows the woman and understands what complications she may be experiencing. So it's one of those things that when I looked at the ACOG letter, it was heavy on rhetoric, short on substance. And so if it actually engaged on the law and said, well, this is what we don't understand, that could be helpful. But ultimately, if you look at the law, every law within the states that have pro-life laws, they're very clear. And ACOG could choose to do one of two things. One, they can continue to be an activist organization with the rhetoric that they're using today, or they can actually do what you mentioned, provide clarity to medical professionals on the ground to help interpret or to share what you don't even have to interpret. You just have to say, this is what the law allows you to do. You are free to go ahead and intervene in these situations where women are presenting with life-threatening complications due to abortion drugs. There is no moral or legal qualm to get involved at this point. And so, at least under federal protections, I have to note the moral qualms that the Supreme Court does allow for conscious objections. But at the same time, when a woman's experienced a life-threatening complication, as we've all argued, and Apolog was one, you would intervene in those situations no matter what. It just presents a difficult situation, but obviously you would still get involved. So all that to say is, again, these are perpetuating lies, and a part of the problem with perpetuating these lies is it does create confusion,
Right.
even though the law is clear. If you tell everybody, oh, the law is unclear, you have to wait till the woman's on her deathbed, as certain people in elected office are saying these days.
Yeah.
That does create a cloud of confusion that we should not let them perpetuate, but that's what's happening here.
Yeah, absolutely. Well, and the other objection that I've heard, and again, as a lawyer, I'd like to get your feedback on this, is that, well, how is a doctor supposed to know, how sick is sick enough, that sort of argument. And I think a lot of that hinges on that reasonable medical judgment language. Is this new language in the law? Did we just all of a sudden come up with this language for these pro-life laws that have passed since the Dobbs decision, or is this something that has some legal precedent to it?
This is language that's in there for many contexts, and why this is probably, I would argue that this is probably from like the medical profession would lobby for this language, because this is what they're used to. As long as you're being reasonable, and you don't have to be right, you just have to be reasonable in your determination, and that gives us so much deference to the doctor to do the right thing. And so that is something that's, in the law, the legal profession, we understand what that means. It's in many different tort contexts. You want to have the reasonable person, reasonable doctor. As long as it's within reason, you're going to be covered and protected by the law. And so it's only when you do something extreme where you look, whoa, that was unreasonable. But that is a rare situation. Those are the outliers where in any context where why would you amputate someone's arm for just a little paper cut, right? Like that would not be reasonable. But that's not these situations. These seem pretty clear cut. And that's why most Americans, when they read these stories, are horrified that these women did not get the medical treatment that they needed, because I would say 100 times out of 100, people are going to say it's reasonable to treat her in that situation. And that's all you need to know as a medical doctor.
Absolutely. Well, and documenting. I mean, I learned all through my training that in order to not only protect yourself from legal action, but also to help people to understand why you came to the decision that you did for a course of treatment for your patient, you document. And that's how we prove that this was reasonable medical judgment. You document the risks that she was facing, her clinical condition, all of that. And that will be the support that you need for your reasonable medical judgment. And I also think that it's really, really ironic that ACOG is saying that this is so vague. These laws are so vague because we can't possibly create an exhaustive list to give physicians direction, when they do this kind of thing all the time. They make lists for things that we can't possibly make an exhaustive list for. One perfect example of that is one of their documents, and I apologize to our listeners, I don't have the number in front of me right now, but they have a practice bulletin on indications for late preterm or early term inductions of labor. And they acknowledge in that document that the list of conditions they give that would qualify for one of those inductions is not exhaustive. However, it is a list of the most common conditions that we would see that would necessitate one of those inductions of labor. This is the same sort of thing, and I'm going to tell you all about some resources later that we have at Apolog that have listed out those most common conditions and when we might need to intervene to do a maternal fetal separation, even if that's pre-viability because of risk to life of the mother. And so I think for ACOG to say that these laws can't possibly stand because we could never create an exhaustive list is really disingenuous, and I think shows their true agenda here. Erik, I want to focus on what I found to be, I think, the most bold statement that they made in this letter, that I think really reveals their true agenda and is quite extreme. I want to get your thoughts on this. So one of the quotes from the end of this letter is, "There is no edit, no amendment, no addendum to these terrible bans that can undo the harm they have created and allow for full access to care. Simply put, abortion bans must be repealed in order to ensure full access to safe, essential reproductive health care for all people." Erik, what are your thoughts about that statement? I'd say it's pretty clear what their position is, but what are your thoughts on that?
My thought, it's way out of the mainstream where most of Americans are today in terms of what should be the line for pro-life or pro-abortion laws out there. To say that there should be no restrictions, no protections whatsoever up until birth, that's not in the woman's best interest, right? Like to have informed consent, to tell her things, to have parental consent and involvement. These are things that people all agree on. And yet what they're essentially advocating for is an elimination of all those types of protections for the woman, for her baby. And so I think it's extreme and not in touch with where most Americans are today. And so I only put that out there in the sense of like that can't be right. That's that's obviously an unconscionable position to be in, but that's where they are. Most Americans are somewhere else, more in the middle at this point in time. And obviously we advocate for life here, but at the same time, like where they're at is in the polar opposite, and it's disconcerting because ACOG holds himself out to be this mainstream organization, and I think maybe historically they were, but at this point they have gone so far off on this extreme that I think people should second guess or like think twice before they take a recommendation or take the words coming out of ACOG's mouth.
Yeah, absolutely. Well, and for an organization that claims to represent all OBGYNs across the country, I think a statement like this is really tone deaf to where the majority of their membership is. We know that 76 to 93% of OBGYNs do not perform induced abortions. So the vast majority of OBs are not performing induced abortions ever in pregnancy, much less later in pregnancy in the second and third trimesters, when, as you said, the vast majority of the American people don't even support abortion being legal at those points in pregnancy. And yet ACOG is advocating for no restriction, no gestational limits on abortion, no safety and health regulations on abortion. And that is woefully out of step with the vast majority of their membership. And I would encourage anyone who's listening or watching who is an ACOG member still, go and look this statement up from October 3rd. It was a news release on October 3rd on their website. And let ACOG know what your thoughts are about what it is that they're saying, and whether or not you agree with there not being any restrictions or regulations whatsoever on abortion.
I was going to ask, like, do ACOG members have any recourse? Can they say, stop, spending my dues money towards these advocacy efforts, which are clearly out of line with the vast majority of ACOG members?
Yeah, well, I would encourage ACOG members to do that. I personally haven't paid ACOG dues for about 10 years because of their radical position on abortion, and because 8% of ACOG dues go to support their political activity, which involves advocating for abortion without any kind of restrictions. But if you are still a dues paying member of ACOG, I would encourage you to reach out to ACOG and let them know if you don't support this agenda, because your dues are going to help finance this agenda. And I do think it would be important for ACOG to hear from you, to know that they're not representing you. I don't know that I expect ACOG to completely agree with me or with APLOG on this issue, but again, we should at least agree that women deserve accurate information, doctors deserve accurate information about these laws so that they can take good care of their patients, and so that we don't see more of these tragic deaths happen that absolutely could be prevented legally in every state in this country. Eric, we do know that even though the laws are actually very clear, and every law or every state law in the country allows for doctors to intervene when a woman is facing a life-threatening complication, there has been some reported confusion on the part of physicians, as we said, because they haven't been receiving accurate guidance. Is there anything that you can see that we could do to help clarify this confusion? Are there laws that need to be fixed, or do we simply need to be explaining them better? What are some things, from a legal perspective or from an attorney's perspective, that you could see that we could be doing to help educate doctors and the public better about these?
Yeah, this is something I'm looking into, whether we can do, whether maybe it's a joint ADF APLOG initiative, but educating the doctors, because clearly ACOG is not doing a good job of it. Somebody needs to fill that void and make sure doctors know what the laws allow them to do and when to treat a woman. Because if these stories are true as being reported by these outlets, then something needs to change. If ACOG is not going to do the educational component, then I think lawyers and medical associations should get together and talk about this. And how do we do? Is it through just putting out white papers? Is it through continuing educational programs? Something needs to change, because we don't want these situations to occur, and they shouldn't occur, frankly, because the law permits women to receive their life-threatening interventions. And so we're looking into that because we want to get the word out there as much as possible. And I know some other organizations are probably doing this too, but in an effective way. I want to continue to do that from the ADF perspective as well.
Absolutely. I 100% agree. APLOG from the beginning, immediately after the Dobbs decision started educating physicians to help them to understand that they could continue to provide life-saving care to women. One of our members, Dr. Jeff Wright, who's a maternal fetal medicine specialist, wrote an article entitled "What is Not an Abortion?" that again gives the list of conditions in which physicians might need to intervene to provide life-saving care to women. We also have on our website, under the resources section, a committee opinion entitled "State Restrictions on Abortion, Evidence-Based Guidance for Policymakers" that goes through the health effects of restricting abortion, as well as the times where we can intervene. And that's a very helpful resource. And also, Applog, actually, by the time this podcast airs, it might be out. And if it's not, it will be out shortly after this podcast. We have a medical education video coming out with another one of our maternal fetal medicine specialists, helping explain to physicians how they can know when to intervene, and that it is very much common sense and very much in line with how most OBs have always practiced. In fact, the only people's practice who needed to change after these state laws went into effect were those doctors, that small minority of doctors who were doing elective induced abortions. They were the only ones who needed to alter their practice. And I think it's important for people to know that and remember that. Erik, any last thoughts? And then also tell us after that, where can people go to keep up with all the important work that you all are doing at ADF?
I always like to say, don't take my word for these things when we're talking about, like, say, the state laws or the Georgia's laws. And recently, the attorney for Miss Thurman's family came out and actually expressly said, even under Georgia law, the doctors had a duty to save Amber. He explained that she had taken abortion pills and there were tissues left. There was no viable fetus or anything that would have prevented them from saving her life while she suffered. So even her lawyer, who's a nationally prominent lawyer, who's not in association with the pro-life movement at all, came out and said it was not Georgia's law. So I say shame on you, ACOG, shame on you, other folks in elected office who have the bully pulpit and refuse to recant the accusations against Georgia's laws and other state laws when those laws are very clear. And even the attorneys for the victims' families are now coming out and saying it wasn't the state's laws that prevented her help, getting the help that she needed. Yeah. So I want to stress that, because some people are like, oh, that's this Erik Baptist at ADF. No, it's not actually. It's her family's lawyer saying this as well. And that's an important thing to keep in mind as well.
Absolutely.
And of course, to keep up with the latest and greatest stuff that ADF is working on, go to adflegal.org. We have a whole life page and you can follow our litigation, but we do many other things outside of the world of life as well.
Amazing. Amazing. Thank you, Erik. And we will put in the show notes as well a link to a Twitter thread that Applog did after the story of Amber Thurman broke, where we detail through how her doctors could have and should have intervened, as well as some of the other resources that we've referenced today. And if that medical education video is available when this podcast comes out, that will be linked in the show notes as well. So keep an eye out for that. Thank you, Erik, so much for being with us. I love having you on as a guest, and I know there's going to be a lot going on as we move into 2025, and I'm sure that we will have you back on to discuss how we're continuing to fight for the lives of our patients, as well as the rights of our members to continue to practice life-affirming medicine.
Well, thanks for having me on. I look forward to our next conversation.
Absolutely. And thank you to our listeners for joining us today. If you like this episode, please be sure to give us a like and a subscribe on YouTube, or if you're listening on a podcast app, give us a 5-star review. Before we go, we also want to give a shout of appreciation to our many donors. Thank you for standing with us so much in this fight and equipping our team with the critical resources we require to continue to do this work. If you have not yet given in 2024, we'd greatly appreciate it if you would consider doing so. For more information on ways to give, please visit our website at aaplog.org. As we talk about often on this podcast, it is no exaggeration to say that we are currently in a defining moment for medicine, and every gift, every support that you can give makes a huge difference. So thank you so much, and we'll see you on our next episode.